Buenas tardes.
Good afternoon or good evening. The Madrid Academy of Notaries Publics is closing today the year 2023-2024, and we've got the luxury and honor to have as our guest Jan Lieder, a real authority in commercial law coming from Germany, and he's going to address us and talk to us about the commercial registry in Germany and Spain. And especially regarding this topic, as in many others, we need to learn from the real maestros that are the Germans and their institutions, such as their commercial registry, with over 2 years of history. So with no further ado, Álvaro Lucini Mateo will be introducing him. He's the delegate of the Spanish notaries for Europe in our international section. Thank you very much, José Ángel. It is a real honor to have with us Professor Jan Lieder. He combines an impressive academic record and history with his professional exercise in different disciplines of law. He's a lawyer, he's a judge currently in the Appeal Court of Schleswig-Holstein in northern Germany. He's also been a lawyer in his own country, also in the US, and in the academic sphere, since he graduated in the Jena University in 2003. Since 2006, he's also had an impressive career. He's also a professor in commercial and trade law, also social law, business law, and he's the dean of the Faculty of Law there as well. He's also worked in the Kiel University. He's been guest professor in several universities in Europe and in the US, in Warsaw, in Tiflis in Georgia, in the US. His Masters of Law from the Harvard University. He's also taught there, Stanford, and so on. It would be a whole list of merits, records. He's got plenty of publications, articles. It's been a real pleasure to cooperate with him. We got to know each other some years ago through video conference during the pandemic. Then we had the opportunity to participate in a seminar he gave regarding the participation in corporate law in the field of European Union law. So without any further ado, I would like us all to listen to him in this academic year, 2023-2024. The topic to be dealt with is highly interesting, differences and similarities between German and Spanish commercial laws and registries. Our dean just told me that it's been 2 centuries of age, and based on my experience with Professor Lieder, I can say that he's highly capable of distinguishing both countries and systems regarding legal institutions and the commercial registry. He's got the floor now, Professor.
Dear Chairman, dear committee, ladies and gentlemen, it is an honor and a pleasure for me to deliver a speech at the Notarial College in Madrid. Thank you so much for inviting me. It's so good to be here. Commercial registers are immensely important for legal transactions because they provide significant information about business partners. The commercial register serves as documentation of relevant data for commercial transactions. Part of this protection is a control under register law of company-related processes in the area of constitutive entries. For example, the registration of corporations, amendments to articles of association and conversions such as mergers, split-ups, or changes of legal form are checked prior to entry to ensure that the statutory provisions are being complied with. This has an confidence-building effect and protects the supra-individual interest in the security and ease of legal and commercial transactions. However, a comparative legal survey shows that the organization and reliability of commercial registers vary considerably around the world and even within the European Union. The Publicity Directive, which dates back to 1968 and whose requirements are now consolidated in the Company Law Directive, has led to an initial harmonization. Nevertheless, there are still serious differences. The different organization of commercial registers poses major challenges in practice. In Germany, this applies in particular to the entry of foreign companies in the land register. The following example may serve as an illustration. A Spanish limited liability company, the Registro SL, Sociedad Limitada, which is by far the most common form of association in Spain, represented by its sole managing director, let's call him Juan, has purchased a plot of land in Friburg, Germany. Juan applies for Registro SL to be entered as the owner in the land register. The Friburg Land Registry will only grant this application for registration if it has sufficient evidence of the requirements for the change of ownership. The requirements to be proven include that Registro SL exists at all and that Juan has sufficient power to representation. How can these two conditions be proven? And is it sufficient to submit an extract from the Spanish commercial register? Even if the doctrinal derivations raise some questions, there is a broad agreement in case law and literature that an extract from a foreign commercial register is sufficient if the foreign commercial register is equivalent to the German commercial registry. Relevant for the assessment of equivalence are in particular, first, the institution maintaining the register, second, the verification of the identification of the applicant, third, the material verification competence of the institution maintaining the register, and fourth, the publicity effect of the commercial register entry. In the following, the German and Spanish commercial register systems will therefore be analyzed from a comparative perspective. In Germany, the commercial registers are kept by the local courts. Personally responsible are judges or judicial officers who, just like judges, are also independent of instructions and part of the judicial structures organized under public law. The independence of the judiciary, in particular, is generally regarded as an indispensable guarantee of quality for the commercial register. In this context, it should not go unmentioned that a good 20 years ago, there was a discussion in Germany about externalizing the task of commercial registers. Register management was to be transferred to the chambers of industry and commerce. The reform proposal ultimately failed because it was feared that a loss of independence on the part of the register-keeping body and the responsible persons would lead to significant losses in the material accuracy and reliability of the German commercial register system. So the German system of preventive administration of justice is therefore still based on the independence of the institution maintaining the register, as well as on the neutral and sovereign legal status of the notary. In Germany, entries in the commercial register require public certification of application to the commercial register, during which the identity of the applicant is verified by a notary. The verification of identity of the applicant is of particular importance in the notarial processes because it provides full proof in legal transactions as part of a public deed. In addition, commercial registers do not carry out any further identity check, as the register itself has no possibility of carrying out its own checks. Instead, the notarized statement is accepted without any further verification. In accordance with Section 15 of the German Commercial Code, this enjoys the full publicity effect in legal and commercial transactions. Identification by the notary is therefore of central importance for the notary's filter and discharge function in connection of the notarization, and it promotes the overall security and ease of legal transactions. In particular, the involvement of the notary significantly reduces the workload of the registry court. The main reason why the companies involved do not have to appear in person at the office keeping the register is that the notary has already reliably identified them and has stated this in the minutes. The register court may rely on these findings made in the notarial record and typically does not need to make any further inquiries. Overall, professional and properly formulated applications and registrations ensure that the register is executed smoothly. In this regard, the notary acts as a gatekeeper and ensures that only those formation documents that comply with the content requirements, such as for a legal form, reaching the registry court. The notarial preliminary examination and the subsequent examination by the court go hand in hand and remain the equal two pillars of the German commercial register system. This cooperation between the registry court and the notary is shaping the system of preventive administration of justice in Germany. There is no doubt that this dualistic system is typically more time-consuming and costly in the run-up to registration than other register systems in other jurisdictions, particularly in Anglo-American law. However, these costs are typically more than set off by a higher degree of legal certainty and the completeness and substantive legality of registers, a higher level of minority and creditor protection, as well as low information costs and other downstream costs. From a legal economic perspective, the German system of preventative administration of justice reduces the cost of dispute resolution in particular because the notary's involvement in the formation of the company helps to ensure that the established company can act with legal certainty in its subsequent phases of life on the basis of a professionally examined articles of association, and that disputes about its content and legality are largely avoided. Accordingly, the notary has a gatekeeping function in the area of preventative administration of justice that should not be underestimated and which can not be replaced by an examination by the registry court. This is demonstrated not least by the examination of registrability incumbent on the notary. Part of the control function is also the notary's obligation to secure the tax revenue and to combat money laundering and terrorist financing. The German Commercial Register does not limit its examination to the formal correctness of documents submitted, but also regularly carries out a substantive examination of the registered content. The specific scope of the material examination obligation depends on the normative registration requirements of the respective registration status. When a corporation is formed, the right of examination by the court extends not only to the facts to be registered, but also to the entire formation process. The purpose of register control is to ensure compliance with the mandatory statutory formation requirements. In particular, evidence must be provided of a formally effective articles of association, which must be signed by the founders. In addition, compliance with the regulation on raising money must be checked. The entry in the commercial register is of central importance if it is a constitutive entry in which the entry of a fact is linked to the occurrence of a certain legal consequences. This applies in particular to the formation of corporations, which only come into existence as a legal entity upon registration, and only at this point in time when they endowed with the legal characteristics that characterize the respective type of company. The entry in the register is specifically constitutive for the creation of the limitation of liability to a company's assets. In addition, a registration is a prerequisite for the effectiveness of amendments to the Articles of Association of a limited liability company, the GmbH, or our stock corporation, the Aktiengesellschaft. Furthermore, mergers, split-ups, and changes of legal form only become effective following a constitutive entry in the register. The German Commercial Register guarantees comprehensive publicity effects. These publicity effects serve on the one hand to ensure the security and ease of commercial transactions by making the most important legal relationships of merchants transparent for everyone. On the other hand, honest participants in commercial transactions can rely on the completeness and material accuracy of the entries on the basis of Section 15 of the German Commercial Code. Firstly, if a fact